And our guest is Dr. Rahjes McEowen, who ag law specialist at the Washburn School of Law. And so I guess the next question is, what role does Packers and Stockyards play in all this? Because I think that's maybe the missing link that isn't brought up maybe enough in trying to figure this all out.
Yeah, I think that's the key point, Ken, because a key provision in the Packers and Stockyards Act, even though it's very broad legislation, but the key provision says that a packer cannot use any unfair or unjustly discriminatory or deceptive practice or device or engage in any course of business with the purpose or with the effect, it's the word or is in there, with the effect of manipulating or controlling prices or creating a monopoly in the buying and selling of livestock. And so it's that effect language that is the key. Do you have to prove that, what do you have to prove in showing that there is a violation of Packers and Stockyards Act? Does it mean what it says? If you show that they have effectively created a monopoly or in effect have price manipulated, do you win your case? Well, some may remember in 2004, the jury in the Pickett versus IBP-Tyson case came back with a $1.2 million verdict for the cattle producers, saying, yeah, you just showed that Tyson-IBP had manipulated price. They had controlled price. They showed the effect of that. That's all you had to show. But then the court tossed that, and later courts have followed suit in saying, no, effect means you have to show an intent to affect price and without any good business reason for doing so. And it has to affect the market as a whole, which is a very high standard. And that's really where the focus has been the last 8-10 years from a regulatory standpoint at the GIPSA level, the sub-agency under USDA, in promulgating regs as to whether it's an effect reg or whether you have to show more than just an effect on price. And so that's why the current request for DOJ to look into this again is there, because they've never really settled that issue.
There's a lot of discussion in the countryside of maybe regional packers would make their way, but some are saying, could there be retaliation from these big four if you try to do that? It kind of goes back to where we were some 35 years ago. Would that be a possibility? Not only from just a structural standpoint, but from a legal standpoint, to have a true level playing field?
Well, the agricultural producers, and this includes cattlemen, this includes hog producers, they have an exemption from antitrust law if they want to use it. And that's in the Capper-Volstead Act. They can form a cooperative and they can price manipulate. They can create a monopoly with respect to the selling of their ag products, whatever they want to do. There is an exemption for them that was specifically put in Capper-Volstead Act. And I think they need to start looking at the possibility of doing that, what the cost is, can they overcome whatever it is that's prevented them from doing this in the past, and say, we're going to process our own product here, whether that's hogs, whether that's cattle, and we have an exemption from antitrust law as agricultural producers to do that. This may be the time, better than any other time, for that to be investigated as a viable option.
Rahjes McEowen is the Kansas Farm Bureau Professor of Agriculture Law and Taxation at the Washburn School of Law in Topeka. He's been our guest. Stay with us. We'll have more coming up.